Thank you. Thank you very much for coming. I know that this is not the most immediately riveting of subjects and that we are after lunch, but I'll try and make it as interesting as I can. The changes that were introduced, the new protocols that became effective as of the 31st of July 2013, there's the expanded and revised pre-action protocol for low-value personal injury claims and RTAs, and then the two new protocols that were introduced for low-value PI, employer's liability, and public liability claims. I haven't been able to obtain any figures for the number of claims that are now processed via the portals, but the numbers are obviously extremely high. It's illustrative that the figures that are available from May to December in 2013, apparently just under 500,000 claims were submitted through the old RTA portal. So I presume, working on those figures, that we're probably looking at upwards of about 1.5 to 2 million claims per year. The small claims track threshold was increased to £10,000, and there's an upper limit on the thresholds of £25,000. The intention, which has been made very clear both by Rupert Jackson and by other senior members of the judiciary, is that all fast-track cases, it is planned, and lower value multi-track cases, possibly up to claims with a value of up to £250,000, will be subject to fixed cost regimes. Apparently legislation is going to be coming through in respect of the fast-track matters in particular as a matter of some urgency, though of course predictably there's no word as to when that might be. In summary then, it's very, very clear which way the wind is blowing at the moment, and fixed costs are here, and they're here to stay, and certainly early indications are that they've been pretty successful and that there has been an increase in the amount of litigation that's being submitted through the portal and processed through this regime. The fixed costs are governed by Part 45. Dealing firstly then with the protocol claims, they break down into two particular sorts. There are the claims that remain within the protocols, where appropriate fixed costs apply. Those, of course, are the most straightforward ones. Then there are the claims that start within the protocols, but then exit, where expanded predictable costs, as per Part 45 from the fixed cost matrices, apply. Those are fiddly, simply because you have to go through the matrices, you have to work out at which stage you're at, which stages you are likely to progress through, at which stage potentially the matter exited the protocol. But nevertheless, it's all set out within Part 45, and if it isn't particularly intuitive, at least it's logical. Then there are the claims which are excluded from the protocols altogether, and therefore, of course, excluded from the expanded predictable cost regime, on which I'll be speaking later. In respect of costs, of course, it's to the advantage of the defendant if a claim remains within the protocol, and to the advantage of the claimant, of course, if it does not. If a claimant gives notice that the claim is unsuitable for the protocol, the claim exits the protocol, but there is a cost sanction in place set out at Rule 45.24, and if the court finds that the claimant's behaviour in exiting the protocol was unreasonable, the court retains the power to award only Stage 1 and Stage 2 fixed costs. Why might a claim exit the portal? If the defendant disputes liability, or if a defendant alleges contributory negligence. Essentially, this is likely, I think, in some cases to be a commercial decision, particularly regarding contributory negligence and whether or not it ought to be pleaded. Obviously, if contrib is likely to be substantial, then it may very well be worth pleading. If not, if potentially you're looking at a figure of perhaps 10% contributory negligence, I think it's worth considering whether or not there will actually be any saving in raising the issue of contributory negligence and thereby seeing the claim drop out of the protocol. There is also a situation where the defendant fails to comply with deadlines. It's a straightforward one. That at least is in the defendant's own hands. Need for careful diarising, etc., etc. Inadequate information in the claim notification form. Now, there again, there is a cost sanction under Rule 45.24, whereby if the court accepts that the claimant provided inadequate information in the claims notification form, then the court retains the power to award Stage 1 and Stage 2 fixed costs only. There is also the situation where the defendant feels that the claim ought to be allocated to the small claims track, and certainly that can be a real bone of contention between the parties. There are a lot of cases that are being pursued through the courts at the moment where the claimant is arguing fervently that this is a matter which ought to be litigated on the fast track. The defendant argues with just as much fervour that it would be better dealt with on the small claims track. It's satellite litigation. It's essentially time-consuming. The courts hate it, but nevertheless it is something that we are seeing more and more and more of, principally because the cost implications are significant. The claim may be revalued at more than £25,000. Here again, this may be a bone of contention. It's worth, I think, taking a very realistic view as to the value of a claim, because further satellite litigation, of course, the claimant can apply for reallocation to the multi-track, where the costs implications are significant. Claimant contemplating applying for a group litigation order, unusual, but the cases do come up. Claimant notifies the defendant that the matter is no longer suitable to proceed through the protocol due to complex issues of fact or law. It's a perennial favourite. It's one that claimants are extremely fond of. It's one that the defendants, by and large, are not particularly fond of. We see it a lot in credit hire litigation, despite the fact that it's the same arguments that are being run time and again. It's an area in which there is, again, likely to be considerable difference between the parties. Complex is more a term of art than a term of great precision. But again, it's something, I think, to which it's worth paying careful attention, because if it is argued that this is a complex matter, then I think real consideration has to be given at an early stage to where any areas of complexity lie and whether it might be worth making timely concessions so that any areas deemed to be complex can be reduced. Of course, it might not be possible, but in situations where it may be possible, it's certainly something that's worth looking at. Offer withdrawn after a consultation period, again, that's a straightforward one. Interestingly, the matter doesn't drop out of the portal where fraud is alleged, which is, of course, far more likely to be the case with the RTA protocol. Apparently, if you press the fraud button when using the claims portal, the claim doesn't drop out, but the other side is alerted to the fact that fraud is being alleged or investigated. Though at a recent FOIL seminar, the Defendant Director of Claims Portal Limited revealed that nobody has yet used the button. Challenging the exit. The cost consequences are set out at Rule 45.24. Costs may be limited to 45.18 fixed costs and 45.19 disbursements if the court deems that the claimant's acted unreasonably in leaving the portal, overvaluing the claim, or failing to comply with the relevant protocol process. Now, the key issue, I think, really is there's a substantive matter of whether the claimant has acted unreasonably, but there is also the question of when to challenge the claimant's notification that the claim is to exit the portal. My advice would be to challenge as soon as possible, to challenge in correspondence, and to give an indication that the court will be invited to apply the sanction set out at 45.24. As to when the matter will come before the court, it'll come before the court once the matter has settled, probably by way of application. As to what, actually moving on to track allocation, this again is material, highly significant in respect of costs. On the small claims track, extremely limited fixed costs are recoverable absent unreasonable conduct. By and large, the costs are limited to fixed costs attributable to issuing the claim. And those costs are set out at Table 1 of Part 45. There's a sliding scale, but they are minimal. And limited costs in respect of loss of earnings, travel expenses, etc., etc. Of course, at the other end of the scale, there is the multi-track, where you would become subject to cost management in the form of cost budgeting, but inevitably and invariably the process is infinitely more expensive and far more costs are expended on behalf of both parties. When to challenge track allocation? Again, I would say challenge immediately in correspondence if the claimant gives a clear indication that they wish for that they are intending to seek allocation to the multi-track, or conversely, of course, if the defendant is stating that they're going to seek allocation to the fast track and you feel that it's not appropriate. The absent correspondence, the most obvious stage at which to challenge is at the directions questionnaire stage, giving reasons. There's a specific box to fill out on the form, of course, if you're seeking allocation to a track that would not normally be the one to which the matter would be allocated. I think it is best to provide reasons in as great a level of detail as you can at that point, because inevitably if there is a hearing, or if there isn't a hearing and the judge is simply looking at the questionnaires, the more detail you can provide, the better. If there is no allocation hearing, in the event of disagreement, it is possible to apply to amend the order that's made as to allocation. And of course you can seek reallocation subsequently, or make submissions at the final hearing that the matter should have been allocated to a different track if you feel it's appropriate at that stage. How to challenge track allocation? Now, there are a number of factors here which are also relevant when challenging whether or not a claim should have fallen out of the portal, but Rule 26.8 sets out specifically the matters that are relevant to track allocation. There's value, complexity of issues, number of parties, likely length of trial, number of witnesses, experts, etc., parties' views and the circumstances. The obvious points to make in the directions questionnaire, if you're seeking to argue that that a matter would be most appropriately dealt with on the fast track, is that there is no need for oral evidence from experts. It may be possible to agree the evidence of some of the claimant's witnesses where it isn't felt that their evidence would be particularly contentious, for example in respect of care, and to make points concerning lack of complexity. It may be obvious at an early stage that there are no matters of any great legal complexity. If that's the case, then mention it in the questionnaire. Make it as clear as possible that this is a case that is not going to last for any particular period of time, that it's not a matter that is either complicated or unusual, or conversely, of course, if you wish it to be allocated to the multi-track, make entirely separate points. What is worth noting, Rule 26.82a, is that in assessing the value of the claim for allocation purposes, the court will disregard any amount that's not in dispute. And what is meant by an amount not in dispute is set out at Practice Direction 26.7.41, specifically any amount for which the claimant does not admit liability is in dispute. Now, an intelligent tactic in respect of ensuring that a matter stays on the track that you would prefer it to be on is to make an early offer in respect of undisputed heads of loss in order to bring down the value of the claim. There is case law not at anything above county court level where these matters are invariably thrashed out, but there is persuasive case law to indicate that the portal and protocol processes encourage early settlement, they encourage settlement of discrete heads of loss, and that where it is apparent that a head of loss is no longer in dispute, that head of loss that area of damages will be subtracted from the overall value of the claim for the purposes of track allocation. When offers are being made, they shouldn't be made without prejudice or on an interim basis. If possible, checks should be issued. It simply makes the matter as clear as possible so that when it comes before the court, when the box in the directions questionnaire is being looked at, it's very easy for the judge to look at it and say, well, entirely clear that this is not in dispute and that therefore, based on value, this would be the appropriate track. Judges tend, particularly with cases that are at the lower end of the fast track on the cusp of the small claims track, to look very closely at the value of it. As to complexity, I think they're used to submissions from claimants that cases are more complex than perhaps they are, or conversely submissions from defendants that matters are perhaps more straightforward than they are. If you're a judge in a hurry, and heaven knows they all are in a hurry nowadays, what you tend to look for is the value of the claim. And if you can say, look, this is not an amount in dispute, we've issued a check, or here is or we have conceded these heads of loss in this particular piece of correspondence, they'll knock it down and you will stand a far greater chance of allocation to the track that you're seeking. Exiting the portal, which fixed costs apply? Assuming that the matter is a fast track case, there are the tables at part 45.29. I won't read them out, obviously, that would take a very long time indeed. They are fiddly, but equally they are reasonably straightforward. Different ones for RTA cases, EL cases, PL cases. Broadly speaking, there's not a great deal of difference, although some of the sums are different. It's worth noting the 12.5% uplift, known as the London weighting, if the claimant lives and works in the areas set out in Practice Direction 45.2.6. They're in or outer London, nowhere else at present is mentioned, and VAT is added to those costs. Interestingly, a recent talk by Rupert Jackson, he made clear that he in fact had recommended that there would be that there ought to be significantly higher figures within the cost matrices, but the Lord Chancellor directed the Rules Committee to impose significantly lower figures than those that he had recommended. He has also recommended that the CJC Costs Committee should keep the tables and matrices under review. So it may be that there's an annual review. Equally, it may be that they stay at the same level for a very long period of time. it's certainly clear that there is very little impetus within the system for costs to be increased, and at the moment they are very low, but it may be that they remain low for some time to come. As to additional provisions, at 45.29F, defendants' costs are set out. Defendants' costs are capped at the applicable level at which fixed costs would apply, though they may be less. That's at 45.29F2B. Paragraphs 8 and 9 of 45.29F cover the situation where Part 36 applies, which Judith will be speaking about. 45.29G counterclaims. If the defendant brings a counterclaim including a claim for personal injury under the RTA protocol and succeeds and costs are awarded, then the applicable fixed costs apply. Where a successful counterclaim does not include a claim for personal injury, the order for costs will be for a sum equivalent to 1/2 of the applicable Type A and Type B costs in Table 6, plus the London weighting plus VAT. 45.29H interim applications. Costs awarded against a party shall be for a sum equivalent to 1/2 of the applicable Type A and Type B costs in Table 6 or 6A, plus London weighting plus VAT. And 45.29I, relevant disbursements. Now this is worth looking at in some detail. There's a list of cost of obtaining medical records and reports, non-medical experts' reports, experts' attendance at trial, court fees, advice from specialist solicitor or counsel if the claim is worth over £10,000 and advice is reasonably required to value it. You may be challenged as to whether or not an advice was reasonably required. You may seek to challenge it, but given that the cost is limited to £150, there's possibly not a great deal of point to doing it. Travel expenses, loss of earnings, and more broadly, any other disbursement reasonably incurred due to a particular feature of the dispute, which is vague, perhaps deliberately so, and allows some scope for costs of additional experts' reports, for example, to be obtained. It's not clear yet how far claimants may seek to take the other disbursement reasonably incurred due to a particular feature, but given that the list itself is reasonably exhaustive, I think there will have to be a degree of creativity. It's worth noting, with effect from the 1st of October, CPR Part 45 has been amended to prescribe fixed costs for medical reports and for obtaining medical reports in soft tissue injury cases under the RTA protocol. Rules 45.19 and 45.29 set out the recoverable costs. It's worth noting that they're not very high. It's £420 for a report from a consultant orthopaedic surgeon. Consultant in accident and emergency medicine, 360, general practitioner, 180, going down to answers to questions under Part 35, which will only be £80. So I suspect there may well be a decrease in numbers of medical professionals who are prepared to offer their medico-legal services, but we shall see. Exemptions. Obviously, at present, all non-personal injury or RTA fast-track claims. Disease claims, which were commenced under the ELPL protocol, there is therefore some scope for argument concerning what precisely a disease might be. In Patterson and MOD, it was stated that the word was to be given its natural and ordinary meaning. Mr. Patterson was a serving soldier who had suffered a non-freezing cold injury, which on the face of it is not a disease. One wouldn't have thought. It was argued vigorously. It failed. It's not a disease. Also claims brought under a group litigation order as previously discussed. Again, it's worth noting, once you're out of the portal, out of the protocol, that's it. You can't re-enter. And finally, the discretion to award costs greater than fixed recoverable costs. The court's discretion is set out at 45.29J. The court has discretion to award costs greater than fixed recoverable costs in exceptional circumstances. There's no guidance given as to what those exceptional circumstances might be, and there's at present a dearth of case law specifically in respect of this particular provision. It's worth looking at the case law concerning the old 45.12 test, CPR 45 section 2, where there was a similar exceptional circumstances discretion in respect of the old RTA protocol. That, I think, is probably the most helpful body of law available at present. Again, quite a lot of it is at county court level and therefore not necessarily as straightforward to get hold of, but there are some High Court cases, there are reported cases. It's worth looking, particularly in the costs reports, where they tend to feature more. As to what exceptional circumstances might constitute, we may well be looking at unusual intransigence or unreasonableness, a case of particular complexity, a case which has gone off in an entirely different direction to that which was originally envisaged. But at present, really, I could speculate, but the best guide, I think, is to be found within the case law concerning the 4512 test. I don't have a great deal more to say, really, having gone through all of the fixed costs. I've related it to the questions that were put in the email I received, which I hope have covered most of the areas that people wanted to hear about. But if anybody has any questions, I'd be very happy to answer them as best I can.
Are claims against individuals exempt from the LPL portal? You just listed some exemptions there. So a claim at the moment against a landlord who's been named as an individual defendant, and the claim solicitors is a fixed cost case. The claim solicitor is saying that because it's against a claim against an individual, that the fixed cost regime doesn't apply.
There's certainly nothing I've seen within the protocol to that effect.
Where that is, but I just wonder whether you... Yeah, yeah. But only portal claims fixed costs will only apply to portal claims. So if it falls out of the portal, then the fixed cost regime won't apply if the portal doesn't apply in the first instance. That's my understanding of it.
Certainly, if the portal doesn't apply in the first case, I have to admit it's not a situation that I've come across. I mean, they are right in that you don't pursue a portal claim against an individual, but it would be an unusual exemption. I mean, certainly it's not a named exclusion, but I suppose, yes, logically that might very well be the case. But that, I think, is something that, I mean, nobody wants to hear that they've got an interesting case, do they, legally? But that may well be a legally interesting case, because I can't imagine that was a situation that was envisaged by this regime, not least because it offers significant cost protection for an individual defendant.
Yeah. But also, I mean, a claim is often against an individual, but then you clearly bring it against the employer as well, so you have to look exactly what that exception is designed to mean, really. And I've got lots and lots of claims against the same breast cancer surgeon at the moment, but he's being insured by the medical defence union, and it would be nonsense if there were fast-track claims, they could just pull that part of the process.
I've had less experience with the RTA portal, but even the RTA portal, obviously a lot of RTA claims are issued against individuals, and they don't fall out of the portal.
They don't know. I mean, they're all backed by insurers, I suppose, which might very well be the material difference. But, and certainly it's not a named exception. I mean, I think it's one that would be worth resisting, simply because it seems so illogical. If there is a loophole, there may well be a loophole, but I think it would have to be a loophole, because I can't imagine that it would be intended.
Well, actually, the rules say, just looking at it quickly, and probably we both want to look at it more, but defendant under the RTA protocol, you probably know this, is the insurer of the person who's subject to the claim, unless the context indicates that it means the person who's subject to the claim. So there probably is scope for argument about it if you're uninsured and a defendant, that may not apply, but I think it's something, again, it's not very helpful for us to say, right?
But an uninsured defendant, I can understand, because obviously
but it's
portal's geared up for insurers. But if it's an individual who is insured, is that a landlord in a PL claim? Can't see how that would.
No, I can't.
I mean, as I say, I can't see that it would be consistent with the aims of the protocol, which do actually serve the interests of defendants rather better than they serve the interests of claimants, albeit that it's a swifter process.
I mean, I think the courts are going to bend over backwards not to allow technical exceptions to these rules. So the claimant's going to have to try quite hard to say that it's an insured landlord. It doesn't come as a listing. It's not attractive, is it?
No.
Any questions from anyone else? Well, thank you very much. I'll unclip my microphone.
Right, so I'm going to talk about the rivetingly interesting but very technical area of Part 36 and fixed costs. Could I just
pick up on two things Caroline said before I move on. And I would just like to say we both do a lot of cost work. We've both also done a lot of low-value RTA and ELPL cases in our time. We've both, I think, done quite a lot of work for a firm you may have come across called Armstrongs in Liverpool. So they're a big claimant credit hire firm. I've certainly had the joy of trailing around the county courts dealing with some of their cost cases. One thing I would say is that they know the rules backwards. It's no secret to any of you who've dealt with them, and I'm not breaching any confidence in saying so, but a lot of the big claimant firms will know these rules backwards. They will be very adept at taking technical points. So one of the points I've certainly dealt with is about whether a cheque paid over in respect of part of the claim actually satisfies part of the claim so that the value diminishes. And I'd strongly endorse what Caroline says. If you want to make sure that the value of the claim is either small claim or fast track, send a cheque, make it clear what it's for, and get rid of it and make an admission in the defence if you need to. Because there will be every possible incentive for claimant solicitors to want to try and, obviously, to get claims out of the small claims track. They've always wanted to do that. But more than that, to get them out of the fast track and into the multi-track. And you've got to be able to challenge that. Either to keep it in the fast track in the first place, or to be able to use Rule 4524 and say it was completely unreasonable to try and shift it into the multi-track. And moving on from that, I suppose my general point about Part 36 offers is, and it applies to all litigation, I suppose, but it certainly applies under this regime, and that's got to be make an early Part 36 offer as early as you can, and make a sensible and generous Part 36 offer, because that's the only way to put the claimant under real cost pressure from the beginning. And one thing that will also become clear as I move on is that it is now in the claimant's interest to make an early and aggressive Part 36 offer because of the very substantial benefits that would accrue to them if they beat a Part 36 offer. And if you get an early and what looks like aggressive Part 36 offer from the claimant, you're going to have to think very carefully about whether you accept it or not. I should say I took a case to trial for the NHS Litigation Authority in February of this year. And a Part 36 offer had been made by the claimant. We failed to beat it at trial, and the claimant got, and there wasn't really room for much argument, additional interest on damages, an extra £75,000, indemnity costs and additional interest on those costs. And so that shows you quite how bad things can get if you don't accept a Part 36 offer. I won't tell you what my advice was in that case. So what I'm really only going to talk about today is Part 36 as it applies to the fixed recoverable cost regime. But in the context of that, I'll have to make some general comments about how Part 36 works generally. And you're probably aware there is unfortunately a huge amount of case law on Part 36. But I'll try and keep it as untechnical as possible. So 36(1)(a)(1) says that the CPR just contains rules about offers to settle and the consequences where an offer to settle is made in accordance with this part. And then 36(1)(2), and it's important, says that nothing in this section prevents a party making an offer to settle in whichever way he chooses. So you can still make an old-fashioned, perhaps it's not right to call it old-fashioned, you can make a Calderbank offer if you want to. But if the offer is not made in accordance with Rule 36(2), it won't have the consequences specified in the rules. But the rule itself says that 44(2) requires the court to consider an offer to settle that doesn't have the cost consequences set out in this section. So if you try and make a Part 36 offer and you don't get it right because you fail on one of the technical aspects of it, the court can still be asked to take it into account, and you should certainly be asking that the court take it into account, but it won't necessarily have the automatic consequences that apply under CPR 36. Perhaps more importantly, if a claimant tries to make a Part 36 offer and doesn't get the technicalities right, the case law as it stands at the moment means that they won't get the consequences if they beat that offer at trial. The court, it seems at the moment, can't award that extra money or extra costs under its general cost powers under CPR 44(2). So if you do find that you get an offer from a claimant and you don't beat it, you do want to be looking pretty carefully about whether they got the offer right. What I will say, because I'm looking just at fixed recoverable costs today, is that what 36.12 says is it won't have the consequences specified in 36.10 if it doesn't comply with the rules. This provision doesn't say it won't have the consequences in 36.10a, which I'll come on to show you is the specific provision that deals with fixed recoverable costs. I think that's just a glitch in the rules at the moment, and it's still incredibly important if you try and make a Part 36 offer that you get it right technically. It's not very complicated, but you do need to try and follow the rules. So CPR 36, and you're probably all aware of this, but I'm going to cover the basics because they're so important. CPR 36 is a self-contained code, and that's taken from this case of Gibbon and Manchester City Council. I have to say code is probably the right word because some of this is so technical. But it is a self-contained set of rules to which the ordinary law of offer and acceptance, the ordinary rule of law of contract doesn't apply. And the reason that's so important is if you get a claimant's Part 36 offer, or the claimant gets one from you, and that offer is rejected, under the ordinary law of contract, the original offer would be extinguished. That doesn't work. And I can't emphasise this enough under CPR 36. If you make an offer and you don't withdraw it, the claimant can accept it at any point until the end of the litigation. If you get medical evidence that shows that you've made a Part 36 offer that was far too generous, until you withdraw it, the claimant can come and accept it. And there can be no question of alleging bad faith or any such thing. So you can be very, very careful about that. Equally, if a claimant makes a Part 36 offer and they don't withdraw it and the claim gets better, you can go and accept it. So you need, it's just a question of record keeping really, I think, but you need to keep your eye on that. Now the next point, again this is a general point about Part 36, is that you have to get the wording right. Because I've already explained that 36.1a says it's an offer made in compliance with these rules will have the consequences, but any other offer won't. You'll just have to ask the court to take it into account. Now, there was, and thankfully seems to have died down, there was a whole spate of cases about this. But the Court of Appeal said very firmly that if there's any ambiguity in an offer which is supposed to be a Part 36 offer, because it says at the top this is a Part 36 offer, the court should, as far as possible, try to construe it as a Part 36 offer. But there are some defects which will be absolutely fatal. So, in PHI Group Consulting, which is a 2012 Court of Appeal case, the offer didn't specify a period of not less than 21 days or any period within which the offeror will be liable for the claimant's costs if it was accepted. And that meant it simply wasn't a Part 36 offer. And there was no ambiguity, and so the court couldn't try and find in favour of the party who'd made the offer. It was just finished as a Part 36 offer. Now, that's an example. If you've got a claimant's offer which you've not been, you'd be wanting to see whether it specified a Part 21 period properly. Because if it didn't, you could argue it wouldn't have the consequences. But if you want a Part 36 offer to work in your favour, you have to make sure that it specifies the period within the meaning of the rules. And as I've already said, the court, if it does refuse to apply the Part 36 consequences because it's an offer, you can still ask it to look at the offer, but it's a much more flexible business, and you're thrown back on all those criteria under CPR 44.2, and you know how wide a discretion the court has. One other technical point, which you're all well aware of, no doubt, but you must serve notice of acceptance if you want to accept it. You can't just say that you want to accept it. And again, if you want to withdraw an offer, you have to give formal notice that you have withdrawn it. Just one very recent case that you might not have seen. This is where, this is general Part 36 stuff, but the defendant tried to withdraw a Part 36 offer before the 21-day period had expired, without telling the claimant of the reasons why it wanted to do that. The claimant realised what was going on and tried to accept the offer, and the court said that was fine because the defendant had got no business trying to withdraw an offer on an ex parte basis without any good reason for doing it. So I've said make an early and aggressive Part Part 36 offer, but be pretty careful, it's an offer you actually want to make. Withdrawing it after the 21-day period is a much less difficult business. So let me come on to what I'm supposed to be talking about, which is 3610A. So this is a specific rule which applies to cases which no longer continue under the RTA or ELPL protocol pursuant to CPR 4529A1. So the core requirements still apply if you want to make a Part 36 offer. It must be in writing. It must state on its face that it's intended to have the consequences of Section 1 of Part 36. So all you need is a sentence which says that, but it's sometimes very easy to forget that. It must state a period of not less than 21 days within which the defendant will be liable for the claimant's costs in accordance with Rule 3610. It must state whether it relates to the whole or part of the claim, and it must state whether it takes into account any counterclaim. So that's all you've got to do, but it's worth having a checklist, that you've probably got standard letters that you use. So what happens if you've made an offer and the claimant accepts it within the period of 21 days or whatever you've specified? So what happens in the fixed costs regime is that the claimant will be entitled to the fixed costs in Table 6B, 6C or 6D in Section 3A of Part 45 for the stage applicable on which the notice of acceptance was served on the offeror. So again, like Caroline, I'm not going to go through the nitty-gritty of how to work out what the costs are. It's basically a fixed sum or a fixed sum and a percentage of the damages. It's all clearly set out in the tables. But this is absolutely common sense. If you make a Part 36 offer and the claimant accepts it, they get the cost for the relevant stage at which they've accepted it. So that's, what else would you expect, basically? There's a detailed provision in 3610A3 where you only make a Part 36 offer relating to part of the claim. That's rarely going to happen, I would suspect, in cases that are in this regime. But if you do decide that you only want to make an offer for part of the claim because you think that's the only part that's going to succeed, the claimant can only accept it. If the claimant accepts it and abandons the rest, she will get the fixed costs in paragraph 2, so that's the fixed cost calculated according to the tables. Otherwise, you're going to have to ask the court or try and reach an agreement about who should pay the cost of the bit that you're not trying to settle. So that, again, I think that's relatively obvious stuff. Now, what happens if you make a Part 36 offer, which the claimant wants to accept, but after the 21-day period? And basically, it's a straightforward, again, it is straightforward, I think, working out according to the tables. So that if that happens, the claimant will be entitled to the fixed costs in the table, so the RTA table, the EL table, or the PL table, for the stage applicable at the date on which the relevant period expired. So if you've made a Part 36 offer just after issue, 21 days, and the claimant doesn't accept it until just before trial, the claimant will get the fixed costs calculated as at the cut-off date is the 21-day period for acceptance. And then, as under any ordinary Part 36 offer not under this regime, the claimant will be liable for the defendant's costs for the period from the date of expiry of the relevant period to the date of acceptance. So you get your costs from the end of the 21-day period. So it's straightforward stuff, and helpfully your costs will be calculated in accordance with those same fixed tables, but that's a cap, so the court could award you less. Now, I haven't seen any case law yet, maybe you're aware of some, on the circumstances in which you might get less than the fixed costs calculated under the tables. I would think that most sensible claimants, given the kind of cost that we're talking about, are just going to say, fine, we'll just calculate them according to the table, and we'll set the costs off one against the other. So it's straightforward stuff, but it does obviously put the claimant at risk if they try and accept an offer well out of time. What there isn't in this provision, the 3610A4, is any latitude. If you have a claimant who accepts your offer out of time, this is what will happen. In the ordinary CPR 3610, there's an unless the court orders otherwise provision, and there's case law about when that might apply. The rule makers were clearly not interested in that when they're looking at what happens if a claimant accepts your offer out of time. So this is what will happen. Now, there is a provision saying that if the parties don't agree about the costs, you can go to court. But it's not quite clear to me when that might happen, given that there's no unless the court orders otherwise provision. But I suppose if you couldn't work out, well, for instance, exactly what, if the claimant didn't agree to set off your cost calculating under those tables, you would end up at court. And this rule, 3610A4A, just gives clear that it gives the court jurisdiction to step in if it needs to. Okay, so far so good. 3610A8 says that fixed costs shall be calculated by reference to the amount of the offer which is accepted. So if the claimant was claiming 25,000 and they accept your early and aggressive Part 36 offer at 6, the fixed cost will be calculated. Again, it's common sense, but it's there in the rules. The fixed costs are calculated by reference to 6,000, not the 25,000 that they were claiming. So you just need to be careful about that. 3610A9, where the parties don't agree the liability for costs, the court will make an order as to cost. Well, again, I can't, perhaps you've already come across examples where the court will have to step in. Under 3610, it's not quite clear to me why that should happen, because if you've got the Part 36 offer right and the claimant accepts it out of time, there's this straight set-off provision. But anyway, if the court needs to step in because there's an argument, the court has got the jurisdiction under 3610A9 to do that. And this is the calculation of your costs, where the court makes an order for costs in favour of the defendant. So where the court's actually doing it, the court will have regard to, and the amount of costs won't exceed the fixed costs in Table 6B, 6D, and 6D, less the fixed costs to which the claimant is entitled under paragraph 4 or 5. So that is, again, it's just setting out the mechanics of that set-off calculation that I showed you earlier. And 3610A11 spells out that if the claimant gets some costs and you get some costs, that you are each entitled to the disbursements allowed in accordance with Rule 4529L incurred in any period for which the costs are payable. So if the claimant is allowed costs up to just after issue, get their disbursements up to that point, you would get your disbursements to the end of the period for which the claimant accepted your offer, and then there's this set-off goes on again. One small but possibly important point is the rules under 4529L talk about using specialist solicitor or counsel to value the claim. If you've had to go to counsel, this is something the junior bar was incredibly exercised about. If you've had to go to counsel to look at liability on a claim for which fixed recoverable costs apply, it isn't clear within 4529L that you can recover that cost if you get the costs back. Now, I don't really want to be saying that. And I speak as somebody, I think that EL cases certainly up to 25,000 can be every bit as difficult in liability terms as cases that are worth £250,000. Some of the six-pack regulations are very difficult, but it isn't completely clear. You would have to bring yourself within that extra category of disbursement under 4529 in order to recover the cost. So that's just the glitch you need to be aware of. You probably all are aware of, but we're certainly aware of it in James. Now, just going back to one little wrinkle, the wording of the offer, the standard wording that's been used, if this offer is accepted, the defendant will be liable for the claimant's costs in accordance with Rule 3610A10 of the CPR. It looks to me as though what you should be saying is the defendant will be liable for the claimant's fixed costs in accordance with Rule 3610A of the CPR. You just want to spell out that what you're expecting to pay if that offer is accepted is only the fixed costs. And the reason it is slightly awkward because that first provision of 36.1 that I took you to doesn't say that the consequences of 3610A, but my view is that this is probably what you should be saying, because that's all you're offering. You're not offering to pay the claimant's costs on a standard basis. And if you make a Part 36 offer, generally in litigation, it is clear from the case law that what that carries with it is an order for costs on the standard basis. It's a deemed order. So I think this is quite an important statement. And I don't think if you use that wording rather than the wording at the top, which is the wording for a standard Part 36 offer, that you could be criticised. The court would just say that you were trying to spell out the consequences that you expected to apply. I will just say this, having done one of the cases myself, the reason that's so important is that if for instance, you want to make a Part 36 offer and you think that the claimant is exaggerated, it is not open to you then on assessment to say that you should only be paying 60 or 70% of the claimant's costs. That's the one point you can't take on assessment, because what the claimant has is an order for his or her costs on the standard basis. You can argue that the claimant was unreasonable and shouldn't have issued. You can argue that they shouldn't have spent money on 6 experts because it only needed 1 expert. You can do all of that, but you cannot say on assessment, I only want to be paying 30% of your costs. It is an order for costs on the standard basis. So I think if you want to say we're only paying fixed costs, better to spell it out in the Part 36 offer. I mean, there's a whole talk that I've been at and given about exactly what you can and can't argue on detailed assessment if you've made a Part 36 offer. It's complicated stuff, but that's the general rule. Now, what happens if you end up at trial with Part 36 offers on each side? Obviously, it happens, one hopes relatively rarely in litigation, that you end up at trial with Part 36 offers that haven't accepted, but what happens? So the rules say that there's a special provision that deals with fixed recoverable costs, and it's paragraph CPR Rule 3614A, and what it says is that Rule 3614 will apply with the following modifications. So you need to have both rules out in front of you. And just to recap then what Rule 3614 says, this rule applies, and it now says subject to 3614A. This rule applies where upon judgment being entered, the claimant fails to obtain judgment more advantageous than a defendant's Part 36 offer. So if the claimant fails to beat your Part 36 offer, and the rules now say by any amount however small, so if they get 1p less than your Part 36 offer, or you fail to beat the claimant's Part 36 offer, then what happens? And the consequences can be, certainly for a defendant, and for a claimant now, fairly serious. If the claimant fails to beat a Part 36 offer and you end up at trial, it's much like what happens if they accept your offer out of time, that unless it's unjust, the defendant will get its costs from the date on which the relevant period expires. And that's obviously standard stuff. But the new provision in the rules from the 1st of April 2013 was that unless it's unjust, if the claimant beats its own offer, it will get interest at not more than 10% above base rate, costs on an indemnity basis without having to show that any conduct of yours was unreasonable, interest on those costs at not more than 10% above base rate, and that the biggest single extra thing is an additional amount, not more than £75,000, calculated at 10% of the damages awarded. So that's what the claimant will get if the claimant goes to trial and beats its own Part 36 offer. So what the rule makers were wanting to happen was that you didn't end up at trial when there was a sensible offer. It's pretty tough stuff, really. So just looking at 3610, where a claimant, so leaving aside the fixed recoverable costs regime, and 3614, where the offeree accepts the offer late or fails to beat it, it's the same test. He has to satisfy the court that it's unjust for the usual rule to apply. So if the claimant accepts your Part 36 offer late or fails to beat it at trial, the Part 36 consequences, so you getting your costs from the end of the 21-day period, will apply unless the claimant can satisfy the court that it is unjust for that to happen. I know of one case where the claimant successfully argued that. It's a clinical negligence case where the claimant, an early Part 36 offer was made by the defendant. The claimant said we just couldn't value it. The claimant was a child where court approval was needed. And so even though the claimant failed to beat that offer at trial, it was unjust for them to pay all of the defendant's costs. But again, the courts are going to be, they really want this Part 36 stuff to work. It's going to be, I think, quite hard for a claimant to argue that it's unjust for it not to be paying the cost if you've made an offer which it's failed to accept. And I've set out in my slides, but I'm not going to go through them. There are a couple of cases about the consequences where the defendant fails to beat Part 36 offer at trial. The court will apply those Part 36 consequences. The relevant factors include how long before trial a Part 36 offer had been made. I don't know of a case where the claimant has got all of those consequences, so the additional interest, indemnity costs, additional interest in costs, and the lump sum additional money on damages. But I certainly, in every case that I've seen, the claimant has got some of those consequences. So if you're going into trial with a claimant who's made, you want to be really careful that you don't think they're going to beat it. So in this is the 2013 case, Davison and Leach, not all of the consequences were applied, but the court looked at it was a case where the claimant had to give very, very distressing evidence at trial, and that was one of the factors the court looked at in whether to make the defendant pay extra because it hadn't beaten her offer. And so it awarded interest on costs from the date at which the offer expired, 2% above base rate, the full sum produced by applying the percentage to the amount of damages, so the extra 10% of damages, but no uplift of interest on the damages. And certainly in the case that I took to trial where we failed to beat the claimant's offer, we accepted that we were going to have to pay the extra money on damages, and then there was a bit of haggling about interest on costs. So what does 3614A do to modify the core provisions in 3614? Not that much is the answer, apart from there's one serious, I think, wrinkle. So where the claimant goes to trial and doesn't beat your Part 36 offer, the claimant will get fixed costs to the end of the relevant period, and then you will get your costs calculated in the same way as I've outlined before. So there's a set-off of your costs against the claimant's costs. But where the claimant fails to obtain a more advantageous judgment than the defendant's protocol offer, the claimant gets the fixed costs and pays the defendant's costs, calculated in the same way. But that, in looking at whether the claimant's got a more advantageous judgment, the accrue benefits are knocked off. Because obviously, it would be ridiculous for the claimant to say, well, I got 25,000, but most of that is the accrue benefits that have gone on accruing since you made your offer. And again, in looking at the calculation of costs, your costs will not exceed the fixed costs that are set out in those tables. Now, the slight wrinkle is that CPR 3614A says, 3614 says that it applies as modified by 3614A. 3614A doesn't do anything to modify the provisions that I've looked at already where the claimant beats its own offer. And one of the provisions, if the claimant beats its own offer, is that it gets indemnity costs. Now, does that mean in a fixed recoverable cost case that it gets indemnity costs from the date when you could have accepted the offer instead of fixed recoverable costs? The rule just doesn't say. I think it is incredibly unlikely that the courts are going to want to construe it that way. So simply because the claimant's beaten your offer, they're going to get all their costs on a standard basis. I think it's something that may well end up in litigation, but certainly if you argue it, I would want to argue very vigorously that's a benefit they shouldn't have. They should simply have their fixed recoverable costs. That's the whole purpose of their regime, is to keep the cost down at manageable and known levels. I should also say that there isn't any transitional provision, and this rule about the extra bonuses the claimant can get if he beats his own offer apply to any award made after the 1st of April 2013, not to any offers that were made before that date. So you just need to be careful. Now the other thing is that it's an even bigger thing really, that the rule 3614 doesn't say that if a claimant beats his own offer, she will only get her fixed costs up to the date of that offer. Again, I think that is how the court is going to construe it, to start staying merely because a claimant has beaten the offer that she made, that she should get standard costs effectively throughout, seems to me just ludicrous. And I think that's how the courts will want to construe it, but that argument is possible because Rule 3614 probably hasn't been amended as much as it should have been. What happens if you accept a claimant's Part 36 offer late? The answer is nothing. You can do it. If you go to trial and don't beat it, as I've shown, you might be paying a lot more money. But if you simply say 9 months after the claimant made the offer that you want to accept it, you can do that. But of course, what you will be doing is paying the fixed recoverable cost to a later stage in the process, but that's it. So it's perfectly open to you to do it, and as I've said, that's one good reason for keeping a very good record of what the Part 36 offers were, because it may turn out later in the process that's something you want to do. 4529, F. Caroline's talked through, so I'm not going to. I was going to mention QOCs, so I think I'm going to have to. Qualified one-way cost shifting. How does that interact with the fixed recoverable cost regime? You know what CPR 4414 says, that costs made against a claimant who doesn't have a pre-1st of April 2013 CFA, orders for costs made against a claimant can now only be enforced without the permission of the court to the extent that the aggregate amount in money terms of such orders doesn't exceed the aggregate amount in money terms of any orders for damages and interest made in favour of the claimant. So if you get an order for costs in your favour, you can only enforce it to the extent of the claimant's damages. Now, how does that interact with the provisions that I've shown you for fixed recoverable costs, where you can set your own entitlement to costs against the claimant? So supposing you end up with a case where the claimant's fixed costs are £3,000, your fixed costs are £6,000. So once you've set those off, there's £3,000 left, and the claimant's damages are only £2,000. The net result of QOCs is you can only set off to the extent of the claimant's damages. Tough. So you just need to be aware of it. But the claimant will lose all of his damages on that factual scenario. So that's how it will work. If you manage to come within one of the QOCs exceptions, so those are the 4415 exception, if you manage to strike out the claimant's claim as an abuse of process, the QOCs restriction doesn't apply. So you could in that situation enforce your cost to the full extent of the order, never mind what the claimant wouldn't be getting any damages in that situation. If the claim is fraudulent under CPR 4416, again, you could enforce an order to the full extent. But again, it's difficult to see what money you might have to enforce against, but that's just the wrinkle. All right, that's the QOCs exception. That's all I wanted to say. I'm sorry it's technical. You can certainly have the slides as a handout to take away. Part 36 is a bit of a minefield, so I think I'll end by saying what I said at the beginning. Just make a clear Part 36 offer, follow those provisions about what you need to put in it, and everything should be fine. But you do need to be very careful about getting the wording right, and then also about tracking the progress of the orders of the offers that you've made, so that you don't have a crafty claimant trying to accept it out of time. Be happy to deal with any questions if anybody's got any. Yep. Might get my white book out.
Could you quickly go back to the slide where you mentioned the 610A and making updates in respect of that? I'm just sort of thinking out loud.
Oh, yeah, about the wording of the offer. Yeah. Yeah, probably can't.
Thinking out loud, first of all, if you say you pay fixed costs in accordance with 36.10a, are you potentially limiting yourself to then going back after you've agreed damages and saying that you wanted to pay MOJ costs because it came out of the portal unreasonably?
Yeah, that's a good question, isn't it?
Well, I think you would be.
Yeah, that's a possibility.
So you probably wouldn't want to make that offer and put that term in there if you're thinking, okay, there's been unreasonable exit from the MOJ portal here.
Yeah, because you want to argue the 45/24 restriction.
Yeah.
Yes, I think that must probably be right. It's a good point. I mean, it's difficult because there's a tension between saying that you will be liable for standard costs and saying that you will only be liable for fixed. And it's right that if you simply said we will be liable for your standard costs, or would it be better to make a Calderbank offer in those circumstances?
My view is you make an offer, and I'd be making an offer in accordance with 3610 because it's an agreement to pay the costs on a standard basis, and the definition of standard basis is cost which is proportionate to the mass in issue. And if you've got a case that's clearly within the scope of the fixed fast track regime, then the costs which are proportionate to that are the costs. So my view is to stick with 3610. And also, are you potentially applying terms, because you can't have a Part 36 offer where you apply cost terms. So are you potentially, so you couldn't make a Part 36 offer and agree to pay predicted costs in accordance with 45.9. Are you applying terms when you say 36.10a? And then does that make it an invalid Part 36 offer?
Yeah, I mean, it's a really tricky topic because what you don't want to say is we're making a Part 36 offer, which, as I say, it's clear under Part 44 that carries with it an order for costs on the standard basis, that you're not then saying we will pay your costs with no reference to the fixed cost regime. And you'll recall those two cases, Drew and Whitbread and O'Byrne and Hudson, where the court, and Leahy and Pirelli is the one where it all started. So Leahy and Pirelli Tyres says it's the case which says that if you've made a Part 36 offer which the claimant accepts, that means an order for costs on the standard basis, and it cannot possibly be a percentage then if you can't argue some assessment. In O'Byrne and Hudson and Drew and Whitbread, in both of those cases, in the Court of Appeal authorities, the defendant had agreed to orders for costs on the standard basis, but in one it wanted to say we're only actually paying small claims track costs, and the other it wanted to say we're only actually paying fast track costs. And in both cases, the Court of Appeal said, and it was a real policy decision, it is an order for costs on the standard basis, but you can argue that we should only be paying those by reference to what the fast track costs would have been, or by reference to what the small claims track would have been, which would have been next to nothing compared to what the claimant was seeking. So I agree completely that the safest possible option is to say 3610, which is standard, but you can argue it down, particularly in a case where you want to argue that the claimant has acted unreasonably in taking the claim out of the portal protocol. I still think, I mean, it's somewhat difficult standing up here giving a talk on something which has such big consequences, that if you think if it's clearly a fixed cost case, that the safe thing to do is the fixed costs offer. But if there's any shred of an argument that there's anything else going on outside the fixed cost regime, then I think you're probably right. And the safest thing of all, if you're the defendant, is to make a Calderbank offer, which can have the kind of cost, you can start fiddling around with the cost terms. The difficulty is, as I said at the beginning, that then you're thrown back on the court's jurisdiction under 44.2, and it's much less predictable. But certainly my experience, where defendants have made defective, it's not just my experience, it's the case law, where defendants have made defective Part 36 offers, and I've argued a case on this in front of one of the RCJ masters, the court will be very reluctant not to give you the cost consequences. What the court won't do is give the claimant the big consequences if they haven't got a Part 36 offer right. But yeah, that's a very good point. I'm grateful to you for raising it. And I've now gone on at some length about it. So if anybody, was there another question?
Just thinking tactically, if you've had a defective offer from the claimant, which you don't accept because you think is defective, I'll deal with that later, is the court going to criticise you for not flagging that to the claimant at an earlier stage?
No, I don't think so. But I mean, but there are two different questions, really, aren't there? I mean, if you think it's a sensible offer, you just take it. Never mind the consequences. And the claimant, if you take a claimant's offer, you're not going to get saddled with the extra £75,000. If you think you've got a technical point, well, the courts don't like these very, very technical points about Part 36 offers. They've made that clear. I mean, I suppose if you think it's a case that might end up at trial and you think the claimant's made a Part 36 offer which might bite and you think there's something wrong with it, it might be best, you can see, works both ways, you might be best just saying so, and if they don't do anything about it, you've warned them. But equally, you don't want to spoil the argument you might have at the end of the case. I think on balance, I wouldn't say anything and just sit tight, but if you think it's sensible, don't rely on the technical defect not to take it. Okay. Well, if that's everything.
I just have one other thing.
Yeah, I hope it's not as difficult as the first one. Yeah.
I don't know if you've had any experience of this at all. When a lot of cases are issued and judgment's entered and it's listed for disposal straight away, now what we're starting to see are a lot of firms saying, well, it's been listed for a final hearing, which is the definition of a trial. We get the higher bracket of the fixed costs, but of course the allocation hasn't taken place, so those previous stages haven't been met.
And of course, nothing's been done. Yeah.
There's one decision that I'm aware of in Birkenhead, which is Birkenhead, and they gave them the trial costs. But is this anything that you guys have come across at all?
No, it isn't, but I mean, you know that Birkenhead and Liverpool, where some of the abuses went on, and it isn't, I can see where the arguments come from. It's a clever one, isn't it?
Yeah.
Rules Committee.
Yeah, I mean, is that the only argument, really, that it's got to have been the intention of the Rules Committee that the higher costs can't?
Yeah, but it's not clearly provided for in the rules, just thinking it through. I mean, I meant raise it with the Rules Committee. Because certainly one of the things Lord Justice Jackson looked at was the abuse of listing it for disposal hearings. We all know people turning up doing 8 or 9 in a day for £750 a pop. That's exactly what they didn't want to happen. So this argument is exactly the same kind of argument. So I would just be telling the Rules Committee. Unless I can find any, because the rules would sketch you out of it. But I can't think what the answer would be off the top of my head. And that's what I mean about claimants listers knowing the rules like the back of their hand. Yeah, it's tricky. All right. Okay.
Thanks very much to both of you for taking time to come in. I know it's as you say, a technical minefield. We will appreciate it, and hopefully we can go away and use some of the stuff that you've given us.
Pleasure.
In our
Okay.
cases.